Good evening, everyone. Thank you for coming to this public consultation this evening. The mayor couldn't be here tonight. He sends his regards. He's asked me to chair this consultation on his behalf. Tonight, we're going to be looking at two proposed bylaws, 1647 and 1648. We're going to do them one at a time. I'm going to describe each proposed bylaw. Then the Director of Urban Planning, Frédéric No, is going to present each in more detail. Then we're going to open it up for comments and questions. And then we're going to close. We're going to do them one at a time. So I'll start with draft bylaw number 1647. And I'll read here the description of the proposed bylaw. The purpose of the public consultation meeting is to present draft bylaw 1647, which aims to designate the competent authority for bylaws enforced by the Urban Planning Department. The purpose of the draft bylaw is to clarify the administrative authority responsible for the enforcement of the city's urban planning bylaws, as well as the plumbing bylaws. Furthermore, the bylaw clarifies declaratory provisions relating to the powers of the competent authority, the duties of property owners, as well as the remedies and penalties applicable in the event of an offense. So tonight, as I said, we're going to present, I just presented a summary of the draft bylaw. Frédéric No is going to explain in more detail, and then we're going to open it up for questions. So please, Frédéric No, I give you the floor.
Thank you, Councillor Moss. Good evening, everyone. My name is Frédéric No. I'm the Director of the Urban Planning Department for the City of Westmount. There are two draft bylaw presentations tonight. The first one is a very semantic amendment, so highly administrative. So I will present the highlights because there's some 30 pages of this draft bylaw. So if you're interested in reading this document, it's available on our website under the January 13 regular meeting. So, draft bylaw number 1647. The purpose of this draft bylaw is to designate the role of the Urban Planning Department in the administration of urban planning bylaws and plumbing bylaw. Also, it's also for clarity for the urban planning team and transparency for you residents that ultimately facilitates the communication. As I said, it's highly semantic. We concord some provision from one bylaw to the other, but we also added some clarification that are listed here. First, a framework for expert assessment commissioned by the city, joint inspection. So our team of inspectors sometimes need to be accompanied with specialists like plumbers or engineers to visit. So we clarify the possibility to do so. Then a framework for inspection required by a committee mandated by the council. We do have two committees in urban planning, the PAC, the Planning Advisory Committee, and the Local Heritage Council, or by the Demolition Committee. So there's clarification there. Then a possible recourse to penal or civil provisions under the Act, in addition to all regulatory remedies. Possible recourse against other natural or legal persons who participate in an offense, not limited to the owner. So not only a owner of a property can be in a situation of infraction. It can be a commercial tenant, it can be a constructor, it can be diverse types of persons. Clarification of the procedure for the issuance of a resolution under the SPAIP. This is the architecture bylaw. And finally, validity period of a resolution adopted under a SPAIP. Again, the architecture bylaw. Also, in this should have been there before, but for some bylaws, the SPA-IP, conditional uses and minor exemptions bylaws, there were no penalties written in those bylaws. So when you're doing an infraction, there might be penalties. So we've added the amount of those penalties in case someone doesn't respect those bylaws. This is a sum up. So this is it for this draft bylaw. Councillor Moss.
Thank you, Monsieur No. So now we'd like to open up the floor to anyone who has questions pertaining specifically to this draft bylaw 1647. Please step up to the mic. Okay. I guess everyone's here for 1648.
Would it be all right if we just sort of talk just a little bit about, in terms of, I'd like to ask a question.
Please.
So, just for the clarity of what we're talking about. There we go. For clarity of what we're talking about, Director No, can you describe to us, when we talk about the inspectors or the people who are authorized by this bylaw to go visit buildings in Westmount and potentially give reports or even issue fines, who are we talking about here? Like, what are they employees of the city? Are they police officers? Or who are they?
Yeah, under those bylaws, we call those employees authority having jurisdiction. Those are appointed by resolution by the council, but it's inspectors. In our team, those are inspectors. Those who visit construction sites, follow up on infraction complaints, neighboring complaints. So those are the person who can visit the private properties. Yes.
So just, if I may, Mr. Chair?
Please.
So just so I understand clearly how this works, in the event that a resident is feeling concerned about a building in their neighborhood, and they say, well, I think somebody ought to come and take a look at this, or perhaps they see that there's an infraction that somebody really should do something about. What's the procedure by which a resident should do something? Do they call urban planning or report it on the website, or how do the authorities having jurisdiction find out something needs to be done?
Yeah, it's part of the job of my team to offer this, let's say, service for residents who think someone is doing an infraction, a neighbor or something that is causing nuisance. We have full team available, not only to issue permits, but also to make sure that all urban planning regulation is observed. So my suggestion is to contact urban planning department. Complaints are confidential. Sometimes it becomes obvious when it's a neighboring situation, but still it's confidential. And we are really, it's really part of our job to do that. Yes.
Thank you.
Thank you, Councillor Anderson. Thank you, Monsieur No. I see there's a question from the audience. Could you please just give us your name?
Barbara Wynn,
Thank you.
Metcalf Avenue. Given the problem that happened with the building that is on the Montreal side of Jacques Cartier Bill and the fire, is the fire department included in your committee?
Monsieur No?
No, the SIM, the Service d'Incendie de Montréal, has their own bylaws. So it's really about urban planning regulation.
It is. And so if you have people going in to look, it doesn't include somebody from the fire department.
Doesn't mean that. It just means that it's other regulation.
Okay.
I'm pretty sure they do have the right to access properties, but I wouldn't speak for them.
I would like to know. I would like to know.
Okay. We'll note your question. Thank you.
I have a question.
Yes, Councillor Chomsky.
Thank you. I support the Service d'Aménagement Urbain in their objective of ensuring minimum standards of safety, sanitation, and building integrity, which applies to 48, but in terms of 47, and my concern or my question is related to both of the bylaws. As written, there is a very broad authority that is given for interior entry to residents' domiciles, including the right to inspect, to photograph, to collect evidence. I would like to know what the threshold for interior access to a private residence would be. Would that be conditional on a complaint, credible information about construction that is occurring with or without a permit, where there is an open file? I'd like to better understand the safeguards with regards to privacy and how they would apply for a resident. Thank you.
In general, the authority having jurisdiction, like the inspectors in Westmount, but everywhere in Quebec, because it's under the act from Quebec government, so it's a power given from provincial government, allow municipalities, their specific employees, to have access to properties in order to ensure the bylaws are applied. It's an important power, I agree, that is given to the staff. But this is how it is. So I would say that we do have a lot of files in our department. We do have like 1,200 permits a year to issue, to inspect. We do have hundreds of complaints to inspect as well. So the work schedule is very busy. So we really visit properties when needed. To my experience in Westmount and even before, I never witnessed exaggeration from the inspector about this power given from the government. But yes, this is a big power that is given.
Just a follow-up question.
Please,
Just a follow-up
Councillor
question.
Chomsky.
What would be the decision-making process within the department to authorize the interior inspection of a resident's home? Could you specify who would have to sign off on that?
Of course, and for sure. The indoor inspection is when indoor inspection is required. So if there's no purpose of visiting the interior, there's no reason to go there. And if one of our inspector would go, for some reason, visit the inside of a property with no purpose, it will be addressed to the inspector. But again, I don't say it would never happen, but to my experience here, this is something that I never seen, some exaggeration about the inspection.
Thank you.
Thank you, Councillor Chomsky. Monsieur No. Moving on now to draft bylaw number 1648 on the occupancy and maintenance of immovables. The purpose of this public consultation meeting is to present draft bylaw 1648, which aims to adopt minimum maintenance obligations for all heritage interest buildings within the city. Furthermore, the bylaw seeks to establish for all buildings within the city minimum standards of occupation and maintenance intended to ensure the cleanliness, safety, and structural integrity of buildings in order to prevent and remedy unsanitary conditions and deficiencies that may affect the building or an accessory structure. So again, I call upon the Director of Urban Planning, Frederick No, to give us a presentation about this draft bylaw. Thank you.
Just one little technical issue for those in the room. It shouldn't be long. Unplug and plug.
Sorry about that. We have our in-house experts working on this. Shouldn't be too long. I could maybe mention that I forgot to mention at the top of the meeting here, but the purpose of this meeting is to collect your comments and questions, and if needed, these comments will be reviewed by council as a whole, and if needed, we can change the draft bylaws to suit the comments and questions that we've heard. Now, back to Frédéric No.
Just put it full screen. Sorry, I have to. Oh, okay. If it's big enough for you, I think it's good like this. Okay. Okay. Sorry for the delay. So this is another draft bylaw, 1648, on the occupancy and maintenance of immovable. Again, this draft bylaw is available online. It's all important, but this one is particularly important and interesting. There's like 70-something pages. It's a big document as well. And there we go. So I will present the context, issues, opportunities, next step, and I will end with your question and comments. Context. The Provincial Act to amend the Cultural Heritage Act and the other legislative provision in Quebec require that every local municipality refer in the Act must, before April 1st of this year, adopt a bylaw that complies with the provisions of the Division 12 of Chapter 4 as amended by this Act. So this is an obligation to adopt this bylaw in the next couple of weeks. There's a context, of course. I will read it, it's important. Quebec strengthens the protection regime for heritage building within its territory. All buildings constructed before 1940 are now considered to have potential heritage value. Only RCMs, MRC, and agglomerations may designate building constructed before 1940 as having no heritage value in the form of an heritage inventory. In addition to the identification presented above, a local municipality or the government of Quebec will retain the discretion to designate a building of interest even if it was built after 1940, after 1939. All buildings of local, regional, or national heritage value must be protected by local occupancy and maintenance bylaw, this draft bylaw, in accordance with the Act. At the very least, for buildings of heritage interest, minimal maintenance must be required. We're talking about maintenance. The required maintenance must effectively prevent the need for demolition. At least for buildings of heritage interest, demolition should only be used in the event of damage. In such cases, the program for reusing the land freed up by the demolition regulations takes over and may even require identical reconstruction. In other words, and that's the important summary, in other words, the dilapidation of high-value buildings is an aberration as it is equivalent to demolition by neglect. So this is the term to remember, the demolition by neglect. This is the intent to avoid demolition by neglect, which unfortunately sometimes happens. So this bylaw gives the municipality the power, the tools to try to avoid this to happen. And we see an image here of what would be the first enclosed shopping mall in Canada, built in the wilderness, in l'Estérel, in the Laurentians. Art Deco building that was a gem for lots of people, but it was illegally demolished in 2022. This is demolition by neglect because this building was not maintained. This is one case figure. So, Quebec grants exceptional powers to cities in order to ensure a minimum level of building maintenance, namely high fines up to $250,000 for infractions. We can also require work to be carried out by simple notice. So by simple notice, that means that an inspector can determine that some maintenance must be carried out. While now, it's sometimes required that we do have a report from like an engineer or some other specialist. So it makes the process faster. Carrying out the work at the owner's expense. Priority claim on the property on which the work was carried out. This cost is secured by a legal mortgage on the property. So this is another power that we don't have now. If some owner doesn't do the work, city can do it at the owner's expense. Also, finally, registering of a notice of deterioration in the land registry. Depending on the case, possibility of acquiring the property subject to the notice, either by expropriation or by mutual agreement. It brings us opportunities. The Urban Planning Department wishes to take advantage of the new regulatory requirement in terms of building occupancy and maintenance too. So we're adding some more than the strict minimum, like the expand of the scope of the building maintenance regime. For example, provisions common to all buildings. So it's not only for heritage designated building, but in Westmount, we believe that every building should have a minimum maintenance. We strengthen its power to intervene, particularly for multi-family buildings. For example, we're adding provisions for multi-family buildings, specific for those types of building. Variation in fines, depending on the characteristic of the building. Simple house, heritage house, high value. So it could go from $1,000 to $250,000 fine. Streamline the city's maintenance regime by consolidating applicable standards to a single bylaw. While, as of now, we do have some old bylaws that are incomplete, so we're merging all of this together, plus the requirement for April 1st from the government of Quebec. So it's all inside one big bylaw, this one. Showing you here the next steps. We are now, there was on January 13 the notice of motion adopted by the council. There's now tonight the public assembly, and next step will be on March 3rd in public meeting, the adoption of the bylaw. And for your information, this bylaw is not subject to a referendum approval. This is a requirement from Quebec, so that it partly explains why it's not subject to referendum approval. So with the adoption on March 3rd, we will be on time for the deadline from Quebec. Mr. Moss, Councillor Moss.
Thank you once again, Frédéric No. So I'd like to open up the floor for any questions pertaining to draft bylaw 1647. Please. Could you step up to the mic, please? We can't hear so well up here. Thank you.
My mother told me I had a booming voice. Yeah, sorry, Barbara Wynn, Metcalf Avenue. I'm taking that when I read it, it looked as if it was a lot of historic, but obviously it's not just historic. Okay. Is there any provision going to be made for letting the neighbors in my particular case, neighbors know that something is being done next next, well, in this case, it's the house next to me. You know, if I personally would like to know if any work is being done by the city, anything is being decided by the city about that house that is next to me, if it comes to that point. I feel I'm next door, and also, I have no idea whether that person that lives in that particular house has fire insurance or any insurance. I have no idea. There I am, and this is, you know, a strip of houses. You know that where it is. So these are my concern, because I really feel, I know before that the city has gone in to look at something to do with mold in that house, but nobody told me whether the passes that the city have put on for the mold. Those passes, those are still there. Nobody has really told me that the mold has been cleared. There are things like that that I feel the neighbors should also know. Now, do I have that right? I don't know.
Thank you. Frédéric, do you know the answer?
You're living on Metcalf, right?
Yes.
I think you asked a question to the mayor on a previous meeting about the neighbor situation. You're the one? Okay. I remember the answer from Mr. Mayor. Part of his answer was that one bylaw was coming soon.
Yes,
This is the
this
is a bylaw.
Yeah, this is it.
Yeah.
Okay, so I'm going beyond the bylaw, I realize.
Well,
I think
that's the right tool to address some situation like mold, like maintenance, lack of maintenance.
Yeah.
Of course, before to ask for improvement, we must make sure that there's an infraction to this bylaw. So there would be a need for an inspection from an inspector, then determine if indeed there's an infraction. And this bylaw ultimately would give the right to the inspector to ask the owner to do the maintenance. And if not, and this is new, and if not, the city could decide to do the work at the owner's expense. This is not automatic, but this is a possibility with this new bylaw, which we don't have now.
Okay, good. Yeah. I wonder, how else do you know about whether houses like this come in under these restrictions? How do you know? Who tells?
I think
Am
that's a difficult one to answer, because as you may imagine, the city wants to protect the personal information of the neighbors. We can't tell you what kind of insurance they have or what's going on with their house. But I understand your frustration. If you don't know what's going on, you'll probably think until you see it all fixed up, you'll probably keep thinking something's going wrong. I get it. We'll note the question. I'll ask our DG when I see her next, but my inclination is there's not much information we can share because it's personal information.
Is there anything in there about length of time somebody actually occupies property?
The length of time?
That you know, how many years has that house been left, any house,
Yes.
any property?
I don't
Is
have it
that
offhand. Frédéric or
Is that included?
Dave?
Yeah, correct, because the author is sitting in silence just beside you. But correct me, Dave, if I'm wrong. But it's not about delays of unoccupancy. Someone may live 6 months in Florida or whatever, but it doesn't mean that he doesn't have to maintain his property to have a level of temperature and so on. So there's no. Is there a delay?
Step up to the mic, perhaps. This
Sorry,
is Dave Sylvestre. He's in Frédéric's team.
He's a urban planner.
Hello. So actually, for a long period of unoccupation, so we're not talking about a couple days, but really a long period of time, like years, there would actually be a registry that would be created under the provision of this bylaw.
Okay.
So people who, for any reason that might be fine, are thinking of not occupying the premises, we should be able to have a record of those buildings, and actually, from that point on, be able to do inspection actually asks for a report of the building every 5 years. So to be sure that it's not being dilapidated or demolished by abandonment. And if we do find something not working out, all the other provision would apply, so we would be able to do something about it at that point.
It's
Thank
a
you.
70-something page document, so it's a very detailed document. Thank you, Dave. So there's a lot of tools to ensure, to avoid demolition by neglect or just neglect.
Thank you, Mr. No. We have a comment from Councillor Aronson.
Well, being a nearby neighbor of the building of which we are all thinking today, I took particular interest and I was quite glad to see that Section 30 pertains to what's called an abandoned work site. And it's a violation of this bylaw to start work on a property and then kind of just float away and not come back and finish what you need to do. And so, if I read this correctly, when work that's specified in a permit or a certificate is not completed by the deadline specified in the city's planning bylaw that governs permits and certificates, if the work is left unfinished, there's a definition of what unfinished work would be in here. The property we have in mind here definitely fits this category. Under that circumstance, the owner of the building or the person responsible for the building is in violation of the bylaw. And enforcement actions can be taken to ensure that the abandoned work site is dealt with. And that, as I understand it, and this is all new to all of us, we've got to really dig into it to make sure we've got the mechanics correct. But my understanding is that a series of escalations can occur whereby the owner or responsible person for that abandoned work site would be notified, eventually fined, and the city council can take the decision at some point to complete the work on behalf of the owner and put a lien on their property or bring it to judicial auction in order to get the community's money back after having done the work for that owner. So as I read this, this is a solution to the problem that we have been communally suffering from of the sort of forever renovations, where someone starts something and never quite finishes it, but also leaves it in a state where it's very unpleasant to live next to. And I think, Ms. Wynn, I think this may be the solution to the problem that you and your neighbors have been facing.
Thank you, Councillor Aronson, for bringing this important section to our attention. Ms. Wynn, does that answer your questions? More.
Well, one of the Quebec, one of the notice on the Quebec one is that it's up to the people who own the houses to report that they're not going to be there or that they're not there. Ha ha. Well, a person who is not there is obviously not going to report that they're not there, are they?
That's true, and I saw the same thing, and I laughed to myself because one of the things that constitutes a violation of this bylaw is being one of those responsible people and not reporting it. So if you just go away and you don't report and get on the registry, that if, for example, a concerned citizen, a neighbor, someone notices, this thing should be on the registry and it's not, and an inspector goes down and checks it out and says, yeah, it's been more than 6 months. This should be on the registry. It's not on the registry. Then the person is in violation of the bylaw, and appropriate action can be taken, including perhaps fines or remedial actions.
Thank you,
My
Councillor
mother
Aronson.
also said, don't snitch.
Do-
Thank you very much.
Thank you.
And I'm sure she also told you and everyone else, you finish what you start, including renovations.
Do we have any other questions this evening? Okay, so I think we'll close this public consultation. Thank you all for braving the weather tonight. It's always nice to see people in the audience. Our next council meeting is February 3rd. Hope to see you there. Have a good evening. Thanks again.